New Hampshire is a state where we take, freedom from governmental intrusion pretty seriously. And, like every other state in the country, we have police officers, but it's important for us to know that they're being held to the highest standards, right? Everyone benefits when police officers in New Hampshire really meet those highest standards.
I'm Justin Silverman of the New England First Amendment Coalition. A quick announcement to all New England journalists. Applications for our 12th annual New England First Amendment Institute are now available. This multi-day investigative journalism training program will be held from October 23rd to October 25th in person at Northeastern University in Boston. Learn more and apply at NEFAC.org. I'm here today with Henry Klementowicz, a senior staff attorney at the ACLU of New Hampshire. Henry, thanks for joining us.
Thank you for having me.
Henry, you and your colleagues recently scored a major win for government transparency, specifically when it comes to law enforcement. The case you brought is called Provenza v. Town of Canaan. NEFAC and the union leader filed their own brief in support of some of your arguments. The case went all the way up to the state's highest court. The decision came down last month. But before I have you get to that decision and what it means, start us at the beginning. What prompted this case?
Sure. So ACLU of New Hampshire has been on the lookout for police transparency cases for a number of years because it's such an important, it's really just such an important area of the law because bad things happen in the dark and police officers, we give them a badge, we give them a gun, and it's just so important to our society that we know that, like everybody else in government, that they are held accountable when they make mistakes and that the public can evaluate how the police are doing. Maybe they're doing a good job, maybe they're not. And this was a really important case on that front.
So what are the facts of the case? What actually happened that prompted the lawsuit?
Sure. So the case dates back a few years to a police officer who's named Samuel Provenza, who was then a police officer in the town of Canaan, New Hampshire, who had received a call that a woman was following a school bus around too closely. And according to the local newspaper's reporting, he pulled the driver of the car over. Her name was Crystal Eastman. And a sort of a scuffle ensued. And she, according to her, he ended up pulling her out of the car by her ponytail. And he sort of pinned her to the ground in a way that led to major leg injuries. And so a columnist with the Valley News, that's the local newspaper up there, started writing about this report and really started digging into it because something about it didn't feel right to him. And so ultimately, the town hired an outside party called MRI to investigate whether the police officers' actions with this woman were proper or not. And the Valley News, through Jim Kenyon, had requested a copy of that report. And the town made Officer Provenza aware of that request, and he sued the town to block them from giving a copy of the report to the Valley News. And that's where we got in representing the Valley News.
Yeah, so let me ask you about that, because this isn't your typical public records case where you have someone requesting records and then the agency holding those records says, no, we're not going to give them to you. You have a reporter here asking for records, and then the subject of those records is suing the town to prevent their release. How common is this?
Well, it's a really interesting legal issue that you're raising, and one that we briefed to the court that they didn't really decide. But there's, in New Hampshire, our version of the state FOIA, Freedom of Information Act, is called the Right to Know law. And so one of the arguments that we made to the court was that actually there is no reverse right to know action, and that because the right to know sets a floor for disclosure for a town or a government body and not a ceiling, it's actually improper to sue a town to stop disclosure under that statute. And the U.S. Supreme Court case, in a case from a little while ago, had actually agreed with us under the FOIA and basically said, FOIA is a disclosure statute, it's not a confidentiality statute. We made that argument to the New Hampshire Supreme Court, and they decided it on other grounds. So that issue will live to fight another day. But it happens more than you would think.
So tell us about those other grounds, that particular issue not decided by the court, but what did the court focus in on ultimately?
Yeah, so they sort of decided a couple of statutory interpretation questions about sort of other statutes that are unique to police. But what I think is really important is that this was the first case in New Hampshire that applied the public interest balancing framework to this type of request. So if I may, just in just a little bit of background. So dating back to the 90s, there was a case called Union Leader Corporation versus Fitment, which basically held that there was this one exemption from our right to know statute that covered internal personnel practices. And the court had said in that case, internal personnel practices basically cover all personnel documents, and those documents are per se exempt from disclosure. And that case, in a pair of cases we did a couple of years ago, Union Leader versus Town of Salem and Seacoast Newspaper versus City of Portsmouth, actually overruled Fitterman and said, no, the types of documents in someone's personnel files are subject to public interest balancing. So what a court is supposed to do in that circumstance now under this new law is you look at the public interest in disclosure and you weigh it against any privacy interests that the government might have or the individual. And then you balance them, but with a thumb on the scale in favor of disclosure, because the statute and even, in fact, the New Hampshire Constitution provide these rights of access to governmental records. And so this case was the first case since Fitterman was overruled to really do that in the context of police personnel records.
Interesting. And to just go back to that helpful context for a moment, why the shift? Why was that Fitterman decision overturned?
Yeah, so there were a number of exceptions from the right to know statute that were all subject to public interest balancing, except for this one on internal personnel practices. And the court in another case a number of years ago had sort of said, well, we're not sure if Fitterman is good law, but we're not going to overturn it without anyone asking us to. So we at ACLU found an opportunity to put that question to the court, and they did overturn it because it was really incongruous with both the way that other parts of the right to know statute are considered and also the purpose of the statute, which is really to inform the public. And it says that exemptions from the mandatory disclosure law really have to be interpreted narrowly.
Got it. So you have this case that's overturned. You have this new balancing test that's in place for future cases.
Yep.
This case is the first time that balancing test is used. Help us understand how the balancing test was used in this case, because I imagine you had the police officer in this case saying, wait a minute, not every allegation against me has been proven. This is a violation of my privacy. Like I shouldn't have my reputation as a law enforcement officer, tarnished in this way. So you have these kind of privacy arguments, but on the other hand, you have government transparency and our right to know. Walk us through how the court saw these issues and ultimately tipped that scale in favor of transparency.
So you're exactly right. That's exactly what happened. And sort of an unusual twist about this case is that the report that investigated this police officer's actions actually found them not sustained. And so one of the arguments that the police officer made was, well, there's nothing to see here because the report concluded I didn't do anything wrong. And there's no public interest in the sort of acquittal, if you will. And we said, no, actually, the public has an interest in knowing, was that investigation itself well done? Was it thorough? Was it comprehensive? Did they talk to all the right people? How did they balance conflicting evidence? How do they look at it? And is that an investigation that the public, which paid for that report, can feel proud of? And so, the court, they did a couple of things that I thought were really important. They looked at the police officers' right to privacy. And one of the things that they said was, when an individual becomes a law enforcement officer, that individual should expect that his or her conduct will be subject to greater scrutiny. That is the nature of the job. And I was really heartened to see that because that's something we've been saying for a long time. As soon as you start taking a public paycheck, you put on the badge, you get the gun, you have, you're part of the state's monopoly on the use of force. It's only right that your conduct while on duty is subject to higher scrutiny because you're acting on behalf of the government. And so that was a really important thing that they said. It was a quote from the Wisconsin Court of Appeals, but it's now binding authority in New Hampshire. And that's great. Then they looked at the public interest in disclosure, and they concluded that it was significant. And they said, quote, the public has a substantial interest in information about what its government is up to as well as in knowing whether a government investigation is comprehensive and accurate. And that was exactly the point we were making here, which is, this was kind of a case about, can the police themselves or not? And the only way to know that is to take a look at the reports and say, was this thorough? Did they do a good job? Were there mistakes they made in balancing the evidence? Did they apply the wrong standard? Should this guy have been cleared or not? And that's what the court agreed with. And so we were really heartened.
So where do we go from here? We've got this great ruling. We've got the balancing test now to be used in all future cases. Are there 2 or 3, major remaining issues that maybe you could point to as far as police transparency is concerned?
Sure. So one thing that we're sort of thinking about and looking at is we had a little bit of background. There's something in New Hampshire called the exculpatory evidence schedule, which is a list that is kept by the Attorney General's office that helps prosecutors fulfill their constitutional obligations to turn over to criminal defendants exculpatory evidence in a police officer's personnel file. So, for example, if you're being charged with a crime and the officer who arrested you has previously been convicted of falsifying evidence or something, that's exculpatory evidence to which you're entitled. But the statutes, there are still statutes making some of that information confidential. And so the exculpatory evidence schedule was a tool developed by the Attorney General's office to help prosecutors look up and say, oh, this police officer is on the list. I've got a case with him. I know that there's something I need to turn over to the defendant. And so we worked with the legislature to have that list be made public. And it was, it's a messy process in legislative negotiations. Nobody gets everything that they wanted, but at this point, something like 75% of the names of police officers on the list have been made public. And we're sort of following the process to see if it's working or not. Will it need tweaks? Is it being interpreted by the courts correctly or not? Because this, as you can imagine, is something that has interested the press, the public, the criminal defense bar for almost as long as it's existed.
Yeah. And lastly, as we wrap up here, just for those that haven't had any encounters with police, don't have a legal or journalism background, if you could, in just a couple sentences here, like really explain why this is so important, this Provenza decision. Why should your average New Hampshire resident care?
Yeah. So I'll say, New Hampshire is a state where we take, freedom from governmental intrusion pretty seriously. And, like every other state in the country, we have police officers, but it's important for us to know that they're being held to the highest standards, right? Everyone benefits when police officers in New Hampshire really meet those highest standards. It protects the police officers, it protects the public, it protects people who have been arrested to make sure that they're not falsely convicted. And, if you were stopped by a police officer on the street, you live in the town of Bedford, well, that there's an officer who's on EES. First, just the description just says cover up. And you want to know, is the guy who's pulled me over, have they committed a cover up? Can I expect them to do that to me too, or not? It's all better when there's that kind of transparency and disclosure. Sunshine is the best disinfectant. And I'd be remiss if I didn't say thank you so much to the New England First Amendment Coalition for writing a brief in our case. You all did a great job. It was, I think, impactful for the court, and we're really grateful for that assistance.
And thank you, Henry. Appreciate all the work that you did, and I appreciate you being here to walk us through the details of the case and explain how it all went down.
Happy to do it.